Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. I haven't been posting as much here because I've been over joining the live stream on Nick Rekieta's channel. They've been live streaming the Rittenhouse trial. And if you haven't seen it, I'm going to include a link to his channel in the description below. You should check it out. It is the best coverage of the Rittenhouse trial that you will find anywhere. Of course, it's a live stream of the channel, so it's a big time investment, but it's worth it. There's a lot of discussion about this case in the media. And quite frankly, I think that unless you're actually watching the trial, and especially watching the trial with some intelligent commentary, you're just not going to understand what's going on. One of the questions that's been raised in this trial, however, is the decision of Kyle Rittenhouse to testify. So I want to talk a little bit about what goes into that kind of decision, and I'm going to do so in the Canadian context because I am a Canadian lawyer. So one of the questions that comes up is, do you want your client to testify, or from the client's perspective, do I want to testify in my own defense at my trial? Here in Canada, you have a right not to testify. They cannot make you take the stand at your trial. However, there's a bit of a distinction between the American rule. The American rule is that you can get up and testify. And then from what I understand, and I'm not an American lawyer, so I'm on some shaky ground here. Somebody in the comments can let me know if I'm wrong. But from what I understand, the cross-examination is then somewhat limited to the confines of what was brought up in direct examination. That's not the case here in Canada. In Canada, once you get up on the stand and you've made that call, then the Crown gets to cross-examine you on whatever is relevant and admissible and a proper question. So they're still within the boundaries of, legal evidence and what questions can and cannot be asked, but they can take you outside of the stuff that you talked about in your direct examination. So this is a risk. There is some inherent risk to this because if we look at the Rittenhouse trial, Rittenhouse did pretty good on cross-examination and on direct examination. In fact, he's about as good of a witness as you can properly expect, which is not perfect. No witness is ever perfect, including you. And that includes if you are stone cold innocent, you are not going to make it out of a cross-examination perfectly. Almost never happens. So there is always risk to it. So what kind of factors would I as a lawyer be looking at? And I'm going to stop here just to say this is not legal advice. If you are facing charges, you should be talking about this with a lawyer, specifically looking at your circumstance. YouTube can be great for legal information if you're going to the right places, but it is terrible for legal advice because I don't know you. You're just the person on the other side of the screen. So caution on that element. But in terms of this consideration, there's a number of things I'll look at. I mean, the first thing that I'd be looking at with an accused is what is the accused likely to say? And this might seem a little obvious, but it is a big consideration. If you're saying, hey, listen, I didn't do it, I wasn't there. Well, is that what the evidence says? If you're going to say, I wasn't there, and it's fairly clear that you were because you're there on camera, then in that case, I can't put you up there because it's a situation where if your plan is to go up and lie, I cannot as counsel support that. That is an ethical rule. There might also be questions of, let's say you're not going to lie. Let's say the charge is theft of a motor vehicle, and what you would say on the stand is, yes, I did steal the car and I didn't have permission. Obviously, I'm not putting you up on the stand to say those things. That would not help. Now, you might say, Runkle, how can you defend somebody who sits in your office and says, yes, I stole the car? How can you in good conscience go in there and defend this person? And I can say easily, my job isn't to help the prosecution get convictions. It's the prosecution's job to do that. And you might think, well, how is this good for society? Well, I'm going to explain that because lots of people like to ask this question, and this is a good opportunity to sort of tackle it. So here's the thing. I like that the prosecution and the police and so forth do their jobs and do them well. They should be good at their jobs, which means that when they're walking into a court, they should be pretty confident that they're going to get a conviction because they've done their homework. What I don't want is a system where the police and the prosecution are allowed to be lucky instead of good. What I mean by that is, if they're arresting somebody for being a car thief, they should have some specific evidence that says this is the guy who stole the car was actually stolen. And if they're bringing this to trial, they should be pretty confident walking in that they're going to be able to get a conviction, proof beyond a reasonable doubt, even without my client's cooperation in that. My client has a right not to cooperate in his own prosecution, and in fact, you should always exercise that right. You don't have to help them prove anything against you. This means that they can't just arrest somebody based on, yeah, we think maybe he did it, and we'll find out at trial. They have to actually do their job well. Why do I like that as a random citizen? I'm not out there stealing cars. I've never felt that need. I've never been in the position where I've needed to do that or wanted to do that. But I like not getting arrested because some officer thinks that maybe I could have been the guy who stole a car. And I like not going to trial on matters where they have no evidence, but they're hoping that they're going to be able to, they're hoping that they're getting lucky. So that is, I think, a fundamental and important thing there. That prevents them from just kind of trolling the waters to see if maybe they can get somebody. So you may not agree with me, but I think that this is pretty critically important. So yes, what the accused is going to say, big factor. Another factor is going to be, how are they going to say it? Because one of the things you'll want to do with a witness, if there's any possibility that they might get up on the stand, is go over things with them, prep them for it. And that might involve doing some mock examinations, just to make sure that people understand what's going on. You can't tell people what to say and so forth, but you can look and make sure that they're familiar with what it's going to feel like being up on the stand. Make sure that they're familiar with what it's going to be like to be asked tough questions on cross-examination, and talk a little bit about, courtroom procedure, courtroom practice. One of the things is, if they're being cross-examined, they should answer the question that's been asked, and specifically and directly, and not start going off on tangents, that kind of thing. So there's all sorts of ways that you can get your client ready to testify. And in the course of that, you're going to see how they're going to do. You can have a client who is stone cold innocent, but you still don't want to put them up on the stand because they're going to do terribly. I had a client with an anxiety disorder, and notwithstanding the fact that the evidence made it crystal clear, to me at least, that this client was factually innocent, they still would have done terribly on the stand. Their disorder, which is no fault of their own, would have presented to a trier of fact, either a judge or a jury, as deceptiveness. And I didn't want that, so they didn't testify. That's that's another consideration, and people don't really think about this. There's all sorts of tics or mannerisms. Maybe you're the sort of person who fidgets and likes to play with their pen. Well, how does that look to a judge or a jury? Maybe you've got some other habit. Maybe you have a particular verbal tic or verbal turn of phrase. How is that going to play to a judge or a jury? All of these are going to be potential considerations. The kind of charge is another consideration to have here, because certain charges, and especially certain defenses, may call for an accused to testify. For example, if we look at the Rittenhouse trial, one of the big issues is going to be self-defense. Self-defense has to be, in Canada, raised as an issue. It has to be grounded in there has to be something on the facts that suggests it's a possibility. And then once that happens, the prosecution has to prove beyond a reasonable doubt that it was not self-defense. Well, certain circumstances you can get that it's an issue without having the accused testify. For example, Rittenhouse trial, you've got great video of what's going on. That video makes it fairly clear that self-defense is a live possibility. But what if you don't have this video? What if you don't have anything? What if this is two people who meet alone on an alleyway and your client stabs somebody to death and it turns out that the other person was unarmed? How do you get that this is self-defense unless somebody says those words, unless somebody says, listen, I was being attacked? That might be a situation where the client, the accused, has to testify in order to get that defense in front of the judge or the jury, and says, listen, this is what happened. He attacked me and then I pulled the knife and stabbed him. It was self-defense. I thought he was going to kill me. In fact, that's what he said he was going to do. He said he was going to murder me. That's why I pulled out the knife. It's a situation where you may have to testify. Judge or jury is another consideration, because in Canada, we have a lot more trials that are held in front of a judge rather than a jury. And judges recognize that you have a right not to testify in your own defense and are much more likely not to hold that against you. You have a right not to have that held against you as well. That's part and parcel of the same right. Problem is that juries don't necessarily care about your rights. I don't mean that in a sort of pejorative sense. It's just that juries have a sense of what should happen, and so they may want to hear you deny it just from your own voice. They may say, hey, why is this guy not telling me he didn't do it? Does that mean he did do it? This is especially true for certain kinds of trials, for situations where the defense might be, listen, I didn't do it, say a sexual allegation. Juries may really want to hear that denial from the accused's own voice. This is unfortunate, but it's absolutely a consideration that goes into this. Yeah, there's no way around that. Anyway, these are some of the things that a defense lawyer is going to be looking at in terms of these. Ultimately, in terms of as I said, I've softened a bit on the decision to have Rittenhouse testify. I don't know that it was necessary in the Rittenhouse trial because, quite frankly, I think that the evidence, largely the evidence elicited by the prosecution, really left them with a good case. And I think that actually putting him up on the stand, he did really well, but it looks like it's opened the door to this provocation argument that otherwise might have been very difficult for the prosecution to advance. And so ultimately, this may have ended up being a terrible mistake. It's hard to see. Right now, nobody knows how this is going to go. I know how I think it should go, but ultimately you can't predict juries to a certainty. It's a real tough call on this one. But anyway, thank you for watching. I hope this has been interesting or at least potentially educational. It's, as I said, this can be a real tough decision, and sometimes you just don't know. Sometimes what it comes down to is you'll have a client saying, should I testify? And, sometimes it's a situation where you say, listen, you have the right to decide if you want to testify or not. Here's the factors that are going into my thinking of this, but I don't know to a certainty. I don't know how this is going to result. You have to be aware of what risk you're taking. Ultimately, I personally tend to lean towards not putting clients on the stand where it's not necessary or where you don't have a solid reason to. But you got to be humble with this. At the end of the day, the lawyers get to go home. They get to sleep in their own beds. That's not true of the accused. And we're not fortune tellers. We're not gods. We have skill and expertise and so forth, but we don't necessarily know how things are going to work out. Sometimes we're surprised in one way or the other. This is always a difficult consideration, and sometimes there are right answers. Sometimes there's a clear right or wrong answer, but sometimes there's not. Most cases fall into this sort of gray area where you're having to make a judgment call. And ultimately, that judgment call rests with the client because they're the ones who have the skin in the game. They're the ones where we're deciding where they're going to sleep that night. This is a tough consideration, and as much as we can sort of armchair quarterback, it's still tough. I still hold that it was not the right call to put him up there, but I can't say for certain one way or the other. We're going to have to see how this trial works out, and there may be regrets afterwards. There may not. I know where I'm predicting things. I still predict that Kyle is going to be acquitted at the end of the day. I think that the evidence is very strong, but recent developments with the provocation argument now being on the table, I think that the prosecution they have a chance of threading the needle on this one and getting a jury to convict. I'm concerned by that possibility. Anyway, let me know in the comments below what you think. This is... please like this video, share it with your friends, subscribe to see more content if you found this to be interesting or educational. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Firearms Association; Mike, Kyle Martin, Jean-Guy Toussaint, the CCFR, and the Canadian Shooting Sports Association; At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jane Babin Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., and Drew Elsich, and Aaron Del Salt. Thank you as well to all the $10 supporters who will be in the crawl immediately following, and to all of you who are watching. Yeah, this trial is becoming a bit of a nail biter. I will say I'm enjoying watching it, just as from the perspective of a lawyer. There's a lot going on here, and I am learning a ton about U.S. law by being on a panel with a lot of very skilled lawyers who are, discussing these issues. I recommend checking out the live stream if you've got the time, and don't necessarily trust what you've been reading on this. There's a lot of misinformation out there. I mean, there are some news outlets that are doing their best to communicate what's going on in a fair and open fashion. But there's a lot that are presenting very skewed versions of things. I've said it before. Often when I have, when cases I've run have made the news, I end up looking at the news articles and I can only barely recognize the cases as being ones that I've been involved with. So I really recommend, if you can, tune in, see as much of the original, see what's happening in the trial. It's there's a lot of discussion about this trial going on in the public right now, and I think that if you want to comment intelligently, you really have to have seen the actual trial, or, that's really the only thing to it. There's so many things going on that are being misreported, and that's just the nature of our society, I guess. Anyway, thank you for watching. See you next time.